This case moves fast, but the consequences hit even faster. 2 young defendants, 2 separate pleas, and one chain of events involving stolen vehicles, high-speed pursuits, and serious felony charges. What starts as a routine court appearance quickly unfolds into a deeper story about accountability, risk, and decisions that can change lives in seconds. Watch closely, because what these defendants admit in court today could determine whether they walk free or face years behind bars. And the real question is, did they fully understand the gravity of what they were stepping into?
CR 43295, the State of Ohio versus Shaquan Barker. Mr. Barker is before the court with his counsel, Ms. Van Gundy. Ms. Nicholson, on behalf of the State of Ohio. Ms. Nicholson.
Your Honor, it's my understanding that it will be entering a guilty plea to the 1 count of the indictment, and then we'll be asking the court to order a pre-sentence investigation.
Ms. Van Gundy, is that accurate? All right, Mr. Barker, they're telling me you're going to change your plea to the 1 count of the indictment. We get to change the plea. I am required to go over some things with you. Okay, sir?
Yes, sir.
How old are you?
20.
How far did you go in school?
11th grade.
Can you read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
I have in front of me a document called a change of plea. On the 2nd page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of receiving stolen property, a felony of the 4th degree that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Do you understand the maximum penalty?
Yes, sir.
Now you, Ms. Nicholson.
Your Honor, this case.
Let's pause here because this is a critical legal moment. What the prosecutor is doing right now is laying out the factual basis for the plea. This isn't just storytelling. This is the foundation the judge relies on to accept a guilty plea. Notice how the defendant admits the facts without hesitation. That's huge. By agreeing, he's essentially waiving his right to challenge the evidence later. Also, pay attention to the charge receiving stolen property. Even though he wasn't driving, being a passenger in a stolen vehicle still carries serious consequences.
Would have proceeded to trial. The state would have proven that on or about January 4th, 2026, in Warren County, Ohio, law enforcement had been dispatched because a Dodge Charger and a Cadillac Escalade had been involved in vehicle thefts. The Dodge Charger was pursued ultimately by Franklin. The defendant was a passenger in that vehicle. It had been stolen out of Montgomery County, city of Trotwood, a couple weeks prior to the pursuit that happened.
All right, Ms. Van Gundy, anything on those facts?
No, Your Honor.
Mr. Barker, did you hear the statement that she read?
Yes.
Do you admit and acknowledge that what she said is true?
Yep, it's true.
I'm sorry?
Yes, sir, it's true.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes, sir.
What's your plea?
Guilty.
The court will make a finding. You've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Mr. Barker, what we're going to do now is I'm going to order let's do a level 3 PSI. I'll order the PSI. I'm going to order you released today. My understanding is Montgomery County has a holder on you, correct?
Yes, sir.
All right. I'm going to release you today on your own recognizance, and once you are released and picked up by Montgomery County and transported there, I'm going to have probation.
I think if we leave the monitor, if you release him OR with a monitor requirement, that allows him to physically be released to go to Montgomery County, and then that will allow community corrections to put a holder that when he is released from Montgomery County, he can return here for the monitor.
Okay, so again, there's no sense in me trying to put you on community control right now if in fact Montgomery County is going to place, because their charges are significantly more serious than this charge is, so there's no sense in me trying to do something and then just having to bring you back if they.
This right here is a smart and very strategic move by the judge. Instead of rushing into sentencing, the court is choosing to wait and see how the more serious charges in Montgomery County play out first. Why? Because sentencing in this case could become irrelevant if the defendant is convicted and sent to prison in the other jurisdiction. This avoids conflicting rulings and unnecessary legal complications. It's also a reminder that cases don't exist in isolation. They can overlap, and one decision can directly impact another.
They send you to prison. I don't know what's going to happen there. I mean, if you're found not guilty, then we'll bring you back here, and sentence you then, okay? You have any questions for me, sir?
Yes, I do got a question. So if I'm going to Montgomery County today, right?
Well, I don't control when you're gonna go. Montgomery County will be notified that you're being released, and then they'll send one of their deputies down to pick you up from the Warren County Jail and transport you to Montgomery County Jail. Okay?
If I bond out of Montgomery County, right, I come back here.
Correct.
But if I get released on probation here,
Well, again, I really want to make sure that, that Montgomery County, since their charge is significantly more serious, the allegation is more serious than this allegation, that we figure out what they're going to do first. Who's your judge up there, do you know? Okay. All right, any other questions for me?
no, sir.
Okay. Do you have a bond, you haven't even been arraigned up in Montgomery County, is that correct? Okay, so you don't know. Okay. Let's go on that plan then, and I'll see you back here in a few weeks, okay? All right, sir, thank you.
Thank you, Your Honor.
This is case number 26CR43296, the State of Ohio versus, is it Armon? Armand?
Yes, Your Honor.
Armani, Your Honor.
Armani, I'm
Like the
sorry.
seats.
Armani Kinney.
Yes, sir.
All right. Mr. Kinney is present before the court with his counsel, Mr. Engel. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter, what are we doing?
Your Honor, is that Mr. Kenny is going to be entering a plea to count 1 and 2 of the indictment, fail to comply as a felony of the 3rd degree, receiving stolen property as a felony of the 4th degree. State is asking for dismissal of count 3, and I believe there's a request for a PSI to set the matter over for sentencing.
Is that accurate?
That is, Your Honor.
All right, Mr. Kinney, they're telling me you're going to change your plea to 2 counts from the indictment. Before we get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, Your Honor.
All right, how old are you?
21.
How far did you go in school?
High school, I was a senior in high school, and then I had got expelled when I was from the basketball and football team, but I was supposed to go back this year and get my GED.
Okay. Has anyone promised you how the court would sentence you in this case?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
I have in front of me a document, it's called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, Your Honor.
Did you read this and go over it with your attorney before you signed it?
Yes, Your Honor.
And you believe you understand what it says?
Yes, Your Honor.
This document says you're entering a plea of guilty to 1 count of failure to comply with an order or signal of a police officer. That is a felony of the 3rd degree and carries a maximum penalty of 60 months in prison and a maximum fine of $10,000. The second count is one of receiving stolen property, a felony of the 4th degree, and that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Neither of these carry mandatory prison sentences. The failure to comply also carries with it an operator's license suspension, which is mandatory of 3 years to life, anywhere from between 3 years and a lifetime suspension. Do you understand the maximum and mandatory penalties?
Yes, Your Honor.
Ms. Tranter?
Now this is where things escalate dramatically. We're no longer talking about just possession of stolen property. This is a high-speed police chase reaching 126 miles per hour. That changes everything. The failure to comply charge is extremely serious because it directly involves public safety. Speeds like that don't just put the driver at risk, they endanger everyone on the road. That's why this charge carries up to 60 months in prison and even a lifetime license suspension. And notice, despite all of this, the defendant still chooses to plead guilty. That could mean the evidence is overwhelming, or that taking the plea is the safest legal option.
Your Honor, in addition to the facts alleged in the indictment, this incident occurred January the 4th of 2026, Warren County, State of Ohio. Defendant was operating a vehicle that had been reported stolen. Officers began a pursuit in an attempt to pull him over. The defendant failed to comply with those signals, fled from the officers, reaching speeds of up to 126 miles per hour, numerous traffic violations. Officers ultimately performed 2 controlled stop maneuvers on the defendant, and he was ultimately taken into custody. His passenger were found to have outstanding warrants.
Mr. Engel, anything on those facts?
No, Your Honor.
Mr. Kinney, did you hear the statement that was read?
Yes, Your Honor.
Do you admit and acknowledge that what she said is true?
Yes, Your Honor.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we discussed.
Yes, Your Honor.
What is your plea?
Guilty.
A Finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights, and the court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I'm not going to get into the matter of sentencing today. I'm going to order a pre-sentence investigation. We'll come back in a few weeks and do sentencing at that time. Ms. Tranter, is there anything else?
Nothing, sir. Nothing further.
Mr. Engel?
No, Your Honor.
All right, I'll see you in a few weeks.
Yes, yes, Your Honor.
This case highlights just how quickly situations can spiral from stolen vehicles to high-speed pursuits and multiple felony charges across different counties. Both defendants chose to plead guilty, which means the focus now shifts to sentencing hand. That's where the real consequences begin. The judge's decision to delay sentencing shows how carefully the system handles overlapping cases, ensuring that justice is applied consistently and fairly. But at the end of the day, these outcomes all trace back to split-second decisions that carried long-term consequences. And now, we turn it over to you. You think the system handled this the right way? Or should the consequences be even tougher in cases like this? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.